Good afternoon. My name is LaShawn Strachan. I'm an attorney. I'm here in Winter Haven in Polk County. And I'm here at the Family Law Seminar sponsored by Ms. Will. We are at 3635 Avenue G, Northwest in Winter Haven. We will be here until 3 p.m. If you want to come on out and join us. We have food for you. We have treats for you. I have some good information for you on the legal process of Florida law regarding family law. And I would love to see you at 3635 Avenue G, Northwest in Winter Haven. Just to tell you a little bit about myself, I am an attorney. I've been an attorney for 19 years. My practice is in Tampa, Florida, and I practice mostly in the family law area. Family law area is a huge area of law, and it covers divorces, child support, child custody, adoption, paternity, alimony, all of those types of things. So we'll be going through those things today. But my background includes not only being an attorney for 19 years, I have also been what's called a general magistrate, which is an attorney who acts as a judge over in Pinellas County, and I was hearing cases involving child abuse. Prior to that, I represented different state agencies as a managing attorney in different areas involving family law. I also do wills and guardianships, and also some real estate and some probate, trusts, and guardianships. I said that already. Okay. So today we will focus on family law, Florida family law cases. So to begin with, if you're here today and you have the handout, I'll be going through this handout with you that gives an overview of the family law area. Okay. So family law cases, they involve dissolution of marriage, which are your divorces. It involves child custody and visitation, child support. We'll talk about some equitable distribution of property, and what that is a division of marital property during a divorce. It involves alimony, adoptions, paternity, and name change, just to name a few of what's involved in family law. The family laws are governed by Florida statutes, section 61. And so I know that attorneys deal with laws and the statutes, but if you are participating in a court case, you kind of need to know where those laws are as well, so you know what's required of you. So I'm going to start with a dissolution of marriage, which is your divorce, because a dissolution of marriage case pretty much involves every aspect of a family law case. Everything else, your child support, your custody, your visitation, alimony, your paternity. It even involves like a name change. So it involves every other area of family law. So in a dissolution of marriage, which is a divorce, the first thing we have to determine, was there a valid marriage? So what is a marriage? When we're talking about a marriage that's going to be dissolved, we're talking about a legal marriage. So here in the state of Florida and in every state in the United States, you have to have a license to get married in order for there to be a valid marriage. I hear a lot of people say, we're common law husband and wife. There is no such thing in Florida. That has been abolished 100 years ago. So there is no common law marriage in Florida. So if you didn't have a license and you didn't go through a marriage ceremony, then you are not legally married in Florida. And therefore, there is no grounds for you to get a divorce. So that's the first thing. Florida is what's called a community property state. And what that means is that everything belonging to the husband and the wife also belongs to the husband and the wife together jointly. So what's yours is his, what's his is yours. That's community property. And what it means is that when there is a dissolution of marriage, when there is a divorce, everything has to be divided up. So, for instance, If during the marriage you acquired a home that you're living in, or retirement benefits that accrued during your employment, even though it's your retirement benefits that were dependent upon you working, it still belongs to the spouse as well. Part of it belongs to the spouse. The home, even if it is in one person's name, and that happens a lot, both persons' names will be on the deed and one person will be on the mortgage because of credit reasons. It doesn't matter. It's still a home that belongs to both parties. Those assets would have to be split. So when we're talking about the grounds for a divorce, a dissolution of marriage, Florida is also what's known as a no-fault state. And what that means is that the courts really do not care why you're getting a divorce. The only thing that matters is that you're able to swear to the fact that your marriage is what's called irretrievably broken. And what that means is that you are saying to the court that there is nothing that can be done to save my marriage. That's all they care about, and that's all they want you to allege. So I know I do divorces, and I hear it all the time. People want to tell me the reasons why they're getting a divorce, and they feel wronged, and so they know it's not right, and they want to explain it to the judge, and I have to stop them and say, I hear you, but it doesn't matter. We're not going to get into that. The only thing that matters is that it's irretrievably broken. The second grounds for a dissolution of marriage is when one spouse is mentally incompetent, and they have been what we call adjudicated mentally incompetent. So you have a spouse that maybe suffered a brain injury due to a car accident, or a spouse is suffering severely from some type of mental health issue that makes them unable to make decisions and they are unable to make informed decisions and to make decisions on their life and their family. And the judge has said, you are mentally incompetent. If that person has been mentally incompetent for the last 3 years, that also is a ground for divorce in Florida. That ground is not really used most of the time. People just use irretrievably broken because it covers everything. But that's also a ground. The only other requirement for a divorce in Florida is that the person who is filing for the divorce is a resident of the state of Florida and has been for at least 6 months prior to filing for that divorce. So as long as you are a resident of the state of Florida, you can file for a divorce. If your spouse lives in another state, you can still file for a divorce here in Florida, as long as the person who's filing lives here in the state of Florida. Sometimes there's an issue with that, though. If the last place you lived together as husband and wife was outside the state of Florida, then that is the place where you need to file for a divorce. Okay, so it's the last place you live together as husband and wife. That's really going to control where you file for divorce. Let's talk about the process of a divorce, a dissolution of marriage. So first there is a filing of the petition. The person who files the divorce is called the petitioner. The person who is being divorced, that you're being divorced from, is called the respondent. So the petitioner files a petition. The respondent has to be served. And when I say served, which means he has to be given a copy of that petition, either by a certified process server or by the sheriff's office, and given an opportunity to respond to your request for a divorce, because that's what you're doing. You're requesting that the court dissolve your marriage. The respondent is given an opportunity to file what's called an answer, and that answer could range from, no, I do not want the divorce, I don't agree, my marriage is not irretrievably broken, to, yes, that's fine, we can have a divorce, I just don't agree with what the petitioner included in the asking, or I completely agree, go ahead and grant the divorce. So it doesn't matter what the respondent answers with, the divorce will basically move forward. When there is a filing of a dissolution of marriage, The laws require that both parties exchange financial information. So I do divorces all the time, and I will always ask the spouse that I'm representing, where does your spouse work? What assets do they have? Do they have a bank account? How much is their income? And I get these answers, I don't know, I don't know, I don't know. I know that's common, but when you're filing for a divorce, all of that information has to be exchanged, or guess what? You're not going to be divorced. It is required, judges require it. Yes, I see you looking at me. You have to exchange financial information. Each party has to know everything that the other party has because of this community property, because this is a community property state. What's yours is his, what's his is yours. And so everything has to be disclosed. And so what happens with your disclosure, all of the assets as well as the liabilities, the debts, get thrown into a pot, and then the court starts divvying it up, dividing it up between the spouses. Okay? So that's called your mandatory disclosure, the exchange of financial information between the parties. You will also, or you can also have other types of disclosures through another phase of the divorce called the discovery phase of the divorce. And that's where if you want to take depositions or if you want to subpoena records, and I generally do that when the other side or the other spouse is either what I think is they're hiding assets, or they are trying to conceal assets in some kind of way. They're not doing a full disclosure. They're disclosing half of the information, but not the full information. At that point, you could subpoena additional records. You could subpoena employers to come in and testify to their income, testify to their work hours, testify to assets that are coming in. You could really ask any question you want, whether it's relevant or not. I've been in depositions where the other side, when there's been some infidelity in the marriage and they want to talk about the infidelity, in a deposition you can do that because it's your deposition you're paying for. In a court of law, it's not really relevant. Okay? But that's additional information that will be available. If you're getting divorced in any county in Florida, generally what the courts will do is give the divorcing spouses an opportunity to kind of work out these issues and to agree on how the divorce is going to go. So they will send you to mediation. And mediation is a process whereby both spouses sit down with a neutral third party. And the purpose of that mediator is to try to get both sides to kind of meet in the middle as far as how property is going to be divided. You can also talk about custody of children, visitation of children, division of assets and liabilities, anything, any and everything. Your mediator can try to help bring both sides to the middle. And the reason Florida courts do that is because if you don't agree, if both parties do not agree, and there has to be a trial in your case, the judge is going to make a decision without any thought to what's convenient for you, what works for your family, how your family has lived in the past, and who has done what. It's going to be strictly by the book. And generally, people walk out of a trial unhappy with how the judge ruled, because nobody's going to get everything that they want. You know, I know we watch a lot of TV and we see these divorce lawyers and we see them going in the court, and the other spouse, especially if they've done wrong, they get stripped of everything. Not going to happen in real life. Does not happen in real life. It is against the law in real life for that to happen. Everything has to be kind of equally split. When both parties walk out of the courtroom, they're going to walk out in a pretty much a similar situation. Not with all the assets, not with all the debt. It's going to be equal. Alimony is decided that same way. If one spouse has substantially more monthly income than the other, and I see that a lot in what we call long-term marriages, where one spouse has stayed home and raised the kids and the other spouse has gone out and worked. The one who raised the kids has no independent income. The one that's worked has the income, has the ability to make the income, and then there is a filing of a divorce. And what usually happens is the spouse that stayed home now is left without support. At the end of that divorce, the spouse that makes the money is going to be given at least half of his income to the spouse that has stayed home all of these years and not worked and taken care of the kids. That's what alimony is. Okay, so that both parties walk out in basically the same position. Okay. So we talked a little bit about equitable distribution, the division of assets and debts in a divorce. And so when we talk about equitable distribution, we'll not necessarily talk about an equal division of the assets. It's whatever is fair, whatever is right, based on the contributions to the marriage. Okay. So in my example where one party stayed home to raise the kids, the other party went out and worked, the fact that the party stayed home to raise the kids, that's a valuable contribution to the marriage that the courts will consider. The fact that because this person stayed home, it allowed this person to pursue their career and to excel in their career. This person still contributed valuable resources to the marriage. And that is, you can put a price tag on that. And the courts will consider that as well. Other factors that the court will consider is the lifestyle that the parties enjoyed during the marriage. I have several cases where my clients are financially well off and they've enjoyed vacations, multiple vacations throughout the year. They have property, all of this rental property, timeshares, all of these things that they have. At the end of the divorce, it's going to be, they won't be able to enjoy vacations 2 and 3 times a year because the income now will be split. But they still would be able to enjoy some level very close to where they were when they were married. Okay, it won't be exactly the same because the level of living is going to come down because of the split income, but it will be comparable between the two. Okay, and that's the way the law works. When the court is trying to decide what is fair in the marriage, as far as the division of the assets and the debt within the marriage, the court will also look at any bad behavior that's happened in the marriage. That's where we talk about, if there was a lot of infidelity in the marriage, where one spouse has taken marital money and funds and maybe supported another person, bought another person expensive gifts, maintained the lifestyle for another person. That's considered bad behavior in the marriage. And that kind of information will come in and be considered when the court is considering a division of the assets. Now, I know that's easy to say, but believe it or not, it's very difficult to prove. And it is extremely difficult to prove. And you spend money to prove it, because you have to depose that bad person. You have to find them, you have to bring them in, they have to testify to it, they have to show what they've received. You have to show where the money came from, and you have to show it wasn't, that it was money that was needed for the household. And so it is difficult to prove, believe it or not. Difficult to prove because of all of these factors that have to come in, okay? And then you have to prove the nature of the relationship as well. Okay. All right, another aspect that happens in a dissolution of marriage case is alimony. And we talked briefly about alimony. And so alimony it's called spousal support, just like child support, but it's spousal support. It's one spouse or a former spouse supporting the other spouse during the divorce and also after the divorce. Now, alimony is, it's kind of tricky because the law says depending on how long you were married will depend on, number one, what kind of alimony you get, and also how long you get your alimony. So alimony, there are several types of alimony. There's what's called bridge the gap, which is transitional alimony. There's rehabilitative alimony, and also durational and permanent. And so I'll go through each of them. So bridge the gap alimony is called our transitional alimony. And basically that's alimony or spousal support that's needed to help the other spouse kind of get back on their feet. It's intended to be no more than 2 years. And for a spouse to receive this transitional alimony, that spouse has to have a plan for getting back on their feet. It can't just be you go into court and you say, I just need some help. You have to have a plan. Either you have to say, I'm going to go back to school to get more training. I'm going to be certified in something and I'm going to work toward it. So while I'm getting certified and while I'm getting that training, I need help. And then after that point, I'll be able to support myself. But you have to have a plan. It has to be written. And you have to show proof that you are working that plan in order to get your bridge the gap or your transitional alimony. The second type of alimony is rehabilitative alimony. This is a little bit longer than bridge the gap alimony. It's a little more involved other than just getting back on my feet. It's I need to maybe get my 4-year degree and then I have to get a job and work my way a little bit so then I can support myself. So this rehabilitative alimony is a little bit longer. Again, you still have to kind of have a plan. It doesn't have to be written and supported and provided to the court, but you still have to have a plan for getting back on your feet and getting rehabilitated and getting back into the workforce. Your durational alimony. That's alimony that's considered for a longer period of time, but there is a stop on that durational alimony. So generally, your durational alimony is anywhere from about 7 to 10 years. And for durational alimony, it's only awarded in marriages of a certain length of time, and we'll talk about that a little bit. But there is going to be a stop date on that alimony, okay? And that's usually awarded to people who are still young enough to enter the workforce. They've been in a moderate to a long-term marriage, and because they are now splitting incomes, they need that additional support for a longer period of time. Our last type of alimony is called permanent alimony, and it's just what it sounds like. Permanent alimony. It is from the date that you are divorced until either you die or you get married again. The only 2 ways to stop the permanent alimony. So it's alimony that will continue up until you no longer need alimony. So it's until you die or until you marry again. So the alimony, whatever type of alimony you get, will depend on the length of your marriage. And so the Florida statute is very specific about what alimony can be awarded at what marriage length. So the statute breaks up the terms of a marriage in 3 sections. So you have a short-term marriage, which is a marriage less than 7 years. In a short-term marriage, you're basically only going to get bridge the gap alimony, because the reasoning behind the legislature is you haven't been married that long. Your lifestyle hasn't changed that much. It wouldn't be a whole lot for you to go back to your single lifestyle because your marriage was so short. So you're basically only going to get the bridge the gap, the transitional alimony, if it's warranted. The second term is a moderate term marriage. That's any marriage between 7 and 17 years. And for a moderate term marriage, you'll qualify for a bridge the gap alimony and maybe a rehabilitative alimony, and in certain circumstances, maybe a durational type alimony. More than likely, you won't get permanent alimony for a marriage that's less than 17 years. Even though I think that's a long time, but it's not my decision. You won't get permanent alimony. Now, long-term marriage is anything over 17 years. So for a marriage over 17 years, you could get all of these types of alimony. And you can get all of them in the same case. So you can get bridge the gap, plus rehabilitative, plus durational, plus permanent. You can get, I mean, it's generally not done that way, but legally speaking, you can get all of them in those types of marriage. So you'll get a certain amount for bridge the gap or transitional, and then you'll get a certain amount for permanent, if the circumstances warrant it. So you're not limited to one type of alimony, you can have all of it. And so the factors that the court looks at in determining alimony, so alimony is really determined by whether one spouse can afford to pay and whether one spouse needs the alimony. And you would have to prove that by evidence and show financially that one spouse needs it and the other spouse has the ability to pay. Some of the things the court will look at are the age of the parties on the date that they are divorced, the remaining earning potential of both parties, and the individual financial resources of both parties at the end of the divorce. So say for instance, and I'm not being sexist, it just usually happens this way, where the husband is the one that has the dominant income, the substantial income. And the wife has stayed home and raised the children, but even if she hasn't, she has a lesser income. On the date of divorce, and this is a long-term marriage, she will be entitled to, say his income is, for instance, $1,000 a week. She has she has an income of $100 a week. That's a difference of $900. That $900 will be divided in two, the difference, and the half will be given to the wife, and the husband will be able to keep his half. That's how alimony is really kind of calculated. There is no formula for it, but that's generally how the judges do it. Okay. All right. Another aspect of family law are child custody and visitation. A few years ago, the law changed, and child custody and visitation is no longer written in the law that way. So the terms that we use now are time sharing and parental responsibility. And so what time sharing is your visitation, parental responsibility is basically your custody and what each parent is responsible for. So the state of the law now in Florida is that when we're talking about custody of children and visitation of children, or the time sharing and responsibility of children, the law says that both parents have equal rights to be involved in their children's lives and to also spend quality time with their children. So Florida has, it's not a formal adoption, but the Florida law kind of starts with a 50-50 custody arrangement. Most cases, most judges will start with a 50-50. And that 50-50 custody arrangement can look, I've seen it many ways. It could be 1 week with mom, 1 week with dad, and then you rotate. What's common now, it's called a 2-2-3 schedule. 2 days with mom, like mom will have every Monday, Tuesday, dad will have every Wednesday, Thursday, and they rotate every other weekend. It's 2-2-3. So they generally start with that 50-50 arrangement. From there, they will use, the statute has about 19 different factors that will be considered by the judge in determining what is the best visitation or time-sharing arrangement. And the court will go through each of those factors, and based on the answer to those factors, that 50-50 now will start to adjust. You may get more with mom, less with dad, or vice versa, but it will start to adjust until the court reaches a place where it thinks that is in the best interest of the child. And the best interest of the child is what's going to control, not really what's best for the parent, what's convenient for the parent, it's what's in the best interest of the child. Shared parental responsibility is the law in Florida. That's another place where the judges will start. And what that means is that both parties have to talk and make decisions regarding the child's health, safety, and welfare, their education, their religious upbringing. The parents have to discuss that, even though they're living separately. And so the courts will try to fashion a court order that will kind of force the parents to do that. And the form that's used here in Florida is called a parenting plan. And in that parenting plan, it outlines the responsibility of both parents, who's going to make the decision for education, who's going to make the decision for medical decisions. Sometimes there's different parties. Who's going to decide what school the child goes to, who has to provide access to the child's medical records, school records. Everything is written in there. It's like a 12-page document, but everything is outlined, and it outlines the responsibility of each parent. The opposite end of shared parental responsibility is sole parental responsibility. And what that means is that one party makes all of the decisions regarding the child. They have to discuss it with the other party, but the buck stops with one parent. And usually that's appropriate when you have the other parent who, number one, has not been involved in the life of the child, and or has demonstrated that they may be a danger to the child in some way, either emotionally or physically. I've seen it many ways. They become a danger to the child, so that the court is not going to trust them to make decisions for the child. Okay, so that's where sole parental comes in. Your child custody and visitation is generally done in a divorce, but it can be done outside of a divorce when there is no divorce. I see this type of case a lot when when the parents are not married. And so I represent a lot of fathers, a lot of dads who come in to me and they say, I want to get visitation with my child. Mom is not letting me visit the child, and so we will start this type of case in order for them to get that. Okay. Another big area of law is child support. And so child support, I see a lot of child support cases. Child support can be established through Department of Revenue, child support enforcement, which is what most people I think are familiar with. But child support can also be established through a family court case by just filing for child support. Child support in Florida is very simple because child support is a formula. It's calculated through a formula. The formula is outlined in Florida Statute 61.30. It's outlined, you just follow the formula. You plug in the numbers. It's the income of both parents. It's the expenses of the child, the medical expenses and the education expenses of the child. It's how many overnight visits each parent has in a year. It's plugged into the formula. At the end of the formula, it spits out a number, a child support number. And it's really very little deviation from that number. Okay? And the courts will use that number. Most people are not happy with the number. The person who's receiving child support wants more or expected more. The person who's paying child support thinks it's too high. It always happens that way, but it is a formula, and that's what I try to explain to people. It's a formula. It's in the statutes. There's really no deviation from it. You can deviate in certain circumstances, but generally you're going to pay whatever the formula says. Okay. So that is the child support, and child support will be paid until the child turns 18 or the child graduates high school, whichever is later. So I get a lot of men, mostly, like I said, I'm not sexist, but I get a lot of men mostly who come in and say, hey, my child's 18. And the next question I ask, are they still in school? Well, yeah, but they got held back in third grade, so they're behind. It doesn't matter. It doesn't matter. The law says 18 or graduates from high school, whichever is later. And so that child support will continue to be paid. Years ago, when the child support was being established by the Department of Revenue, they didn't have that language in their orders. And so I'll get, not anymore because those children are 18, but I used to get those men who came in and said, well, the child turned 18, but the child was still in high school, but because the order was written back in 92 or something and didn't have that language, even if that child was in the 10th grade at 18, I mean, it's unlikely, but just as an example, that child support ended. And so you had children who were still dependent legally, but were not being supported. And so the law changed to say 18 or graduated from high school, whichever is less, because they are dependent until they graduate high school. Child support can be extended past 18 or graduation if you have a child with special needs. If when that child support is being established, it's known by both parents at that time that that child has special needs. I've seen it where children have autism or children have cerebral palsy, and they're going to remain dependent. And so that child support will remain past the 18th birthday. Okay. And that's available as well. Okay. Paternity, one of my favorites. It's another area of law. And sometimes paternity is an issue in divorce cases. As I said, divorce cases, they kind of capture all of these areas. But paternity is the establishment of parentage. That's what it means. And so sometimes in a divorce case, I will have the parties who've been separated for years. They both have gone on separate lives. They're both in different relationships. But the wife is pregnant, or the wife had children from another man. The law says that if you are married at the time your children are either conceived or born, then they are automatically considered to be the children of the husband. Even though everybody knows he's not the biological father. He really can't challenge that. The husband really can't challenge that unless the wife says, no, he's not the father. I know, but that's the state of the law. He will be considered the legal father. And if he is the legal father, which means he will be on the hook for child support, he can enforce visitation rights. He gets all the rights as a father, okay? If he's determined to be the legal father, which means he's married to the mother at the time this child was conceived or born. Okay? A lot of fights surrounding that because everybody knows that, they've moved on. And some judges have a hard time with that as well. Not really sure how to handle that when the wife is pregnant or she has other children that were born during the marriage. Because what will happen is that those children, legally now, if the husband says, these are not my children, if the courts were to allow just him to say that, then these children will be legally, and the term is bastards. That's what's in the law. It's not my word, that's what's in the law, which means they have no legal father. And the courts are reluctant to leave children without legal fathers because then they have no support, no financial support. So the law allows, if the mom says he is not the father, this is the father, and he's willing to step into the role of a father, which means he's willing to acknowledge that he's the father, which means he's willing to pay support for that child, then the court will let the husband off the hook for support of that child. Otherwise, he's a legal father. Okay. It's one of the reasons why I love paternity, because it's always so twisty-turny, and you have to figure it out. But generally, I represent men in paternity cases who want to establish paternity to their children. So I get a man who will walk into my office and say, this is my child, I've been supporting them, but I have no say-so. I signed the birth certificate, my name is on the birth certificate, so I should have rights. And my answer to them is, until a court says you are the father, you have no legal rights to that child, even though your name is on the birth certificate. If you have not stepped into a courtroom and that judge has not put your name in a court order to say you are the father of the child, then guess what? You have no rights to the child. You have no rights, and you have no responsibilities either to the child. So invariably, they will come in and they want to establish paternity rights, but then I say, once you do that, we're going to set child support, and then I get it back up, because one doesn't happen without the other. Okay? So if they want rights to children, it doesn't matter if they sign the birth certificate, they have to file a court case. If they are not married to the mother, they have to file a court case. And so they come in and they file that petition for paternity to be established. And in that petition, they have to allege that they were in a relationship with the other party, and as a result of that relationship, this child was conceived, and the paternity can only be established for a child that is actually born. Okay, so I get guys who come in and even sometimes before the child is born, oh, I want to establish my rights. You can't do that until the child is born, and then there's an actual live child. One other aspect of paternity that I like is paternity can be established when one parent is deceased. As long as there's some DNA of that parent that's available from a reliable source, paternity can be established. And I'm doing a case like that now. I've done a couple of them over the last couple of years. But the reason that's done is maybe you want that child to be able to receive Social Security benefits from that deceased spouse or that deceased dad or parent. You can't do that without a paternity determination. Okay. So the one I'm doing now, the dad didn't sign the birth certificate, and then he died unexpectedly before they could establish paternity. And so the mom came to me, she wants to establish paternity. Now we've gotten DNA from the medical examiner's office, and it's a whole big deal, but it can be done. Okay. If you have the foresight to get that DNA ahead of time, before they dispose of it. Okay. And so that DNA can be given by court order and DNA tested and all of that. Okay. Also, if the parents were not married, paternity can be established either by consent of the dad or by DNA testing. And if it's by DNA testing, the dad has to specifically ask for DNA. Okay. Generally, sometimes the mom asks for it, but mostly it's the dad or the potential dad that's asking for that DNA test. And so if that test comes back 99.99% that he's the dad, we take that test to court, present it to the judge, and the judge will do an order saying that he is the father. At that point, his rights as a father are established, which means now he can enforce visitation. He can enforce that parental responsibility that we talked about, be able to be involved in the decisions regarding the child. He can object to things regarding the child. All of his rights as a father is now established by that court order. I know I'm throwing a lot. Okay. But y'all still good? All right. Okay. Another area is adoption. Also a great area. There are different types of adoption. So we have a step-parent adoption, which if, say you marry another guy or girl and you have children and that person wants to adopt your children, that's allowed by the law as long as you have the consent of the other parent. Okay. So I have people come in and they say, oh, well, the dad is not involved in the life of the child. I don't know where he is. My husband has stepped into that role of a dad and he wants to adopt. I'll say, great. Let's find dad. Let's get him to consent. And then your husband can adopt. That's not a popular answer, but it has to be done that way. If that dad who's not involved, if he doesn't consent, or if his rights are not terminated, no one else is going to be able to step into that role legally as a father to that child. And then I also counsel people that once that husband adopts that child, in the unfortunate event there is a divorce, then that husband will be on the line for child support until the child turns 18 or graduates high school, whatever is later. So step-parent adoption, the other parent must consent or have his rights terminated. And that's a separate case within the adoption case. It's called a termination of parental rights, and we will be alleging abandonment of that dad who has not seen that child for more than 6 months, has not provided support for that child, has not been involved in the life of that child in any way. So we can allege abandonment. The only instance where it's kind of tricky for the courts is when that dad is incarcerated, because he's limited in what he can and cannot do for the child. Another way to adopt is through relative adoption. And that's where the child is being adopted by, of course, by relatives who have had custody of the child for at least 6 months. And the grounds for relative adoption is also abandonment. And it's also what is in the child's best interest. All adoptions are what is in the child's best interest. A relative adoption can also happen when there has been a finding of child abuse against the child, and the children have been removed. That's a whole different section of statute. It's Florida Statutes Chapter 39. But that's a whole different chapter, whole different standards. There are different grounds to terminate and adopt based on that chapter. Okay. Adoption agencies also sometimes file for adoption of the child. Generally, adoption agencies will move or request adoption of the child when there is an unmarried mom and dad, when they're not married to each other. They may be married to other people, but when they're not married to each other. In the situation where you have a mom who is not married to the dad, she has almost complete say-so over whether or not her child is going to be adopted. Okay. It doesn't matter if she knows who the dad is. For the most part, whether the dad wants to be involved or not, if she signs that consent, giving that child over to the adoption agency for future adoption, that's pretty much what's going to happen. So I'll tell you an interesting story. I had a case that was similar to this. It was an unmarried mom and dad. And in the beginning of the pregnancy, mom and dad were living together. And then mom moved out, didn't tell dad that she was pregnant. And she moved out. They both went on with their lives. He ran into her out on the street somewhere, saw her someplace, and saw that she was pregnant and started counting up the months and realized he must be the father. Well, before then, she had already signed over this baby to the adoption agency when the baby was born. He came in to my office, and I told him, I was like, I don't think, this is going to go anywhere, but if you want to fight it, I'll fight it with you. And we did, and he lost that. He lost that. He could prove that mom knew he was the father. We could prove that she knew where to find him. He was very stable. He lived in the same place for 10 years, been employed in the same place for all of this. So she knew where he was. She knew where to find him. But it was solely her choice, and that's the way the law is written. It's her choice, what she wants to do with her baby. Unmarried mothers are given a lot of rights in the law. So they determine the name of the baby, and I know we don't think that means anything, but I'll tell you a case. I had when I was working for another agency, a baby who was named after Lil Wayne. You guys know who Lil Wayne the rapper is?
Yes.
She named him after Lil Wayne. And so he had to come in and deny paternity. So the law says, yes, she can name her baby after anybody she wants. She can name anybody to be the dad that she wants. It's up to him to come in and say no. I don't even know this woman. So, an unmarried woman with a child, she has pretty much unfettered control over what happens to that child. Even if the dad signs a birth certificate, even if he's involved, her rights will trump his, because we know she's the mother.
That's right.
Yes. Him, he has to prove it in order to get those rights. And so an unmarried father has to file that paternity case that we talked about in order to establish his rights. He has to get that court order saying that he is the dad. One other thing that I didn't put in my outline is that an unmarried father has to do, and I know this is what the law provides, and I know people don't do this, but if a man has had sexual relations with a woman and he thinks there is a chance that that woman could become pregnant, he needs to register with it's called the Putative Fathers Registry. He needs to register that in that registry to say, I had relations with this woman around this time period. There's a chance she could have conceived and she may have a child. So I want you to know that I may be the father. That will stop any future adoption. That will start the process of him establishing his rights to that child. But the main thing is that it will stop any adoption. Because what's required in the adoption statute is that before a child is adopted, that putative registry has to be searched for the name of the mother and the child and the proposed father. If that father's name is found on the registry, everything stops. Okay? He would have to consent to an adoption. He would have to be given notice of the adoption, and he now has the ability to come in and fight it. And I've never had a case where they've registered, but I imagine that if he came in and fought it on that ground, he would be more successful. And the problem is that I hear men say they don't know this, and I've checked into it, and it was told to me that they are given notice when they first get their driver's license. Who reads that stuff? Who reads it? They're 16. Who reads it? Who thinks about that as they're growing up? But that's the only time they will get that notice. Okay. So I tell people, tell your sons, tell your brothers, they have to register if that's an issue for them. Okay. Last but not least, name change. So it's changing your legal name, the legal name that's on your birth certificate. What happens is that sometimes I get people who their family starts calling them a name. It's not their legal name on their birth certificate. And then when they want to go and get an official document, or they want to get services from the government or something like that, the name that they write is not the name that's actually on the birth certificate. So there's a problem. You have to use the name that's on the birth certificate, and so your birth name is the only name that really can be changed. So if you're going by a different name and you want to be called by that name, you have to legally change it to a different name. You'll get a new birth certificate with that name on it. But a name change can be done by adults. Adults can change their name. Parents can change the names of their children. And then a whole family's name can be changed. I've changed the names of a whole family. People who were new to this country, they both became naturalized. The parents became naturalized citizens, and they no longer wanted to use the name from their country. They created a name for themselves and their whole family, and we changed everybody's name in the whole family. And so the law allows that. It can be done. To change a name is, there's a lot of work involved in changing a name. The application for a name change, or the petition for a name change, asks, you have to list every place you've lived at since your birth. You have to list information regarding your parents, where they lived, where they were born, You have to list your work history for, I believe, 10 years back. And I know we're a transit society, not so much in a community like this, but in other communities, people come and go all the time. And they're like, I don't remember every place I've lived. I don't even remember every state I've lived in. But that's gonna be an issue with you changing your name. Because you have to be fingerprinted. You have to have a background check done by Florida Department of Law Enforcement. And so if something on your application is kind of doesn't jive and it's a little funky, it's gonna be a red flag. And the judge is gonna make that final decision whether or not your name, they're gonna allow your name to be changed. Usually people with an extensive criminal history, arrest history, people who are under investigation for a criminal case, people who have filed bankruptcy recently, people who have any kind of law enforcement involvement probably will not be allowed to change your name. The exception to that that's allowed in the statute is during a divorce. During a divorce, the wife is allowed to change her name basically without any questions asked. So she's allowed to go back to her maiden name. She can't create a name. She's allowed to go back to her maiden name and then go back to using that name. Because the thinking is there's already a birth certificate in her name, in the maiden name, so there's no problem with that. That can be traced back up to where she is now. So those are just some examples of family law cases. So family law cases, your divorce cases will include probably all of this, or can include all of this. Or each of these areas can stand alone as a separate case. The filing of a case in the family law area of Florida, they involve certain forms, certain petitions, things that have to be alleged. And so what the Florida Supreme Court has done is they have created forms for everybody to use, for general people to use, to represent yourself if you wanted to do that in court. And so I put the web address of that website here. It's www.flcourts.org, or you can find these forms on any clerk of court's website, usually on their main page. But there's a list of forms there. Everybody can access them. And they are available for what we call pro se people who are not represented by attorneys, and they're pro se. Clerk websites, they have a lot of information regarding every area of law. Some clerks have instructions on what you need to do after you file a form. If you go on this website, each form on this website has instructions. That's the first page on how to use this form, what this form is for, what you need to do, what other forms you need to go with it. And so the courts have tried, or the Supreme Court of Florida, they've tried to make it as user-friendly as possible for the average person to represent themselves in court and to get the relief that they are looking for in court. Okay. So I know I gave you a lot of information. It was just an overview. Are there any questions, general questions? Because I can, go ahead.
I was going to take a break.
Okay.
And then go back to that.
Sure.
But will you give your name, your location?
Yes.
Because there's people watching on Facebook, so
Okay.
they can contact you if they
Sure.
needed to.
Okay, again, my name is LaShawn Strachan, and you mean my office address, my location.
Mm-hmm.
Okay, so my office is in Tampa, and that address is 5118 North 56th Street, Suite 113, and that's in Tampa, 33610, but my phone number is 813-606-4111. And I think we're gonna take a break, and then we'll be back with questions.